Morning. This is Rich Sierra, CEO of the Florida Small Business Legal Center. This is episode number 50th of Business SOS podcast. Very excited. We're almost at the year mark. Thank you for listening, and I hope that you have enjoyed this podcast every week, and we will be continuing doing this every week for as long as we can to provide you information and that you need, and I believe that you need, that will help you navigate the legal challenges that you will face in your small business. As I always just begin the show, I'd like you to participate in the show. If you have a legal question you'd like me to address in the show, send me an email at rich@richsierra.com. And if I select your question, I'll address it in the show, and I'll send you a free copy of my book, Business SOS, 8 Common Legal Mistakes Business Owners Make and How to Avoid Them, which is available on Amazon, Barnes & Noble. You can ask for it at your local bookstores. Now, today we're going to talk about a brand new law that just became effective yesterday. And when I say yesterday, we taped the show about a week in advance. So this is the new FTC rule on non-compete agreements, which non-competes pretty much are banned now, will be banned 120 days after they publish this in the register. That will ban nationwide. So this affect millions of businesses and millions of employees nationwide. So I thought that it is important to cover that topic. I began to read this yesterday as it became available, and it's about a 570-page document. So bear with me if I refer to my notes as I'm learning this with you, but I want to give you some of the highlights. If you're an employer that has a non-compete agreement for your employees, this affects you. And if you're an employee that also listening to this show as well, that you have a non-compete agreement, this also affects you. So you should listen and understand how does it affect you. And also there's some exceptions to whether or not to whom this law is applied to. So I want to talk about that as well. I might do a follow-up as well on this show as I get more information, I get more clarification, and we get more guidance in how this law is applied, because there's some questions here that are not very clear. So I will go ahead and as I go through the show, I'm going to do a follow-up on this show later on in a few weeks or a few months, just to give you more guidance and how to proceed. And of course, you can always call our office, and we can always discuss it as well if you have any particular questions. So first of all, what is a non-compete agreement? And let's talk with that, and why do businesses have non-compete agreements on their employees? It is a very common practice, and I've spoken about this before. In fact, a few weeks ago when I talked about employment agreements and I talked about independent contractor agreements. So as a business owner, you're concerned about your intellectual property, about your client list, about the methods and how you utilize really your secret sauce, what makes your business run, what makes your business special. So you want to protect that. And there are ways to protect that even without a non-compete agreement, and that's through a confidentiality agreement, a non-disclosure agreement, an NDA. There are ways that you still can protect that, and those documents, those agreements still can be in place. But what happens is that sometimes employers or business owners get a bit overzealous, and they say, I don't want anybody competing against me anywhere. And they create non-compete agreements that, in order to make him as a deterrent for the employees either to leave the company or to compete against them. And they do that with the assistance of attorneys. We mean non-compete agreement, you put one together. And I've seen situations where security guards that are working for a company, in fact, they have examples here of how when they asked for the comments, when they were looking at, the FTC was looking at this rule to implement, you have a security guard that is working for a company that's, say, working for an HOA, just go ahead and doing a working security detail. Then, you have a non-compete agreement that this particular security guard cannot work in a 25-mile radius. it is, that particular job, is important, but it's certainly not something that's the type of job will require confidential information to the extent that if he gets a job at a security company somewhere else, it will really affect the prior employer's business. And that is the reason why this law was implemented, because the belief is that the restriction to employees is too much. If you have a receptionist, if you have kind of a line worker or a position that is not a senior executive, which is in this case is exempt, and we'll talk about that, then the person should be able to work somewhere else, even if it's in a competitor, as opposed to having a 2-year non-compete to work. And that is basically the reason they passed this law. And there's already, actually, as of today, I saw that there was a lawsuit filed by the U.S. Chamber of Commerce in federal court to try to prevent this law from taking effect. So it is still a very fluid situation. We don't know what's going to happen. But as of now, this will be the law in approximately 4 months, and it will be effective. If you're a employer, let me take this one step at a time. If you are a business owner and you have non-compete agreements, they will be invalid for the most part. So you have to go ahead and talk to your attorney and say, to have these employees and have these non-compete agreements, what do I do? And the employer and the attorney should be able to advise you how you can protect yourself now without this non-compete agreement. Number one, in Florida, the laws, you got to have the non-compete agreements, even before the FTC passed this ban on non-competes, they have to be reasonable in scope and geographic limitation. So you got to have, if you got to have specific, and you got to have a legitimate business interest to be able to enforce this non-compete agreement. And it happens in the business of salespeople, for example. You have outside salespeople, you don't want them contacting your clients or train this salesperson to then become your competitor. And they were enforceable up to, now with this law becomes effective, they're enforceable agreements. And I've seen that, for example, in the case of ad agencies that they have. And I remember way back many years ago, before I became an attorney, somebody that I know ended up being sued by his prior employer because he took a job with a different ad agency as a sales rep, as a representative. And what happened with those non-competes are very expensive to litigate, very expensive to enforce, and very expensive to defend. And usually what happens is when the prior employer ends up suing somebody for a former employee for violation of non-compete, they also sue the new employer also for interference with contract. So what happens is that the new employer says, I really don't want a hassle of a lawsuit. I just cannot bring you on board until I get that resolved. Because all they wanted to do is bring somebody else new to the company. They did not want to basically step into a lawsuit unnecessarily. So that employee then becomes unemployed. And that happens very, very frequently. But also what happens is that the employee usually does not have the resources required to properly defend a non-compete agreement. You have a breach of contract claim, you have a temporary injunction motion that is filed as well. So there's just a lot of components there, and then you got to have an evidentiary hearing, you got to take depositions. I remember doing one years back, defending a claim, and it became very expensive for my client. And the actual worker that was actually alleged that she was violating non-compete, it was not somebody that was an executive. So, but everybody has their own opinion on that. But in this particular case, it just became very expensive to litigate. Things got resolved eventually. But my point is that the employee is usually at a huge disadvantage when they're defending these non-competes. Are they necessary? Yeah, in some cases they are. but in some cases they aren't. And I think this is the balance that has to be placed. And we'll find out what happens and what are the results. So if you're an employer at this point, if you're the business owner and you want to have non-compete for every employee, including your receptionist, anybody that works for your office, even if they're not a key employee, that might be challenged. And in this particular case, it's not going to be legal to do that. So one recommendation that I have is that you have to look at your employment agreements now and review them and decide whether or not they have to be amended, they have to be changed to reflect the new law. A question, I'm getting emails now from various clients, and a question that I get now is that, Rich, does this apply to independent contractors? And the answer is yes. The FTC expanded the definition of what a worker is. So it's not necessarily a W-2 employee. It also applies to independent contractors. So if you have independent contractors that have a non-compete agreement, this law will apply as well. So you have to keep that in mind and then look at your independent contractor agreements to see how they have to be changed. And there's a workaround, not around the law, but there's a workaround as to how you can protect your intellectual property, how you protect your customers, how you can protect your trade secrets and their confidentiality agreements and NDAs. So if you have an employment agreement that does not include that, that's something that we can discuss. You can discuss with your attorney and how we can get that can be incorporated so you can still be protected. But if you will not be able to prevent that employee from going to a competitor and working for a competitor, that is going to be gone. Not going to be the case anymore, including independent contractors as well. So you have to be cognizant of that you're going to have an issue if you're trying to enforce these agreements later on. And after this new rule becomes in effect, it's not going to be valid. Now, are there exceptions to this law? The answer is yes. Okay. One of the exceptions that you have is, does it apply for franchisor-franchisee relationships? So if you're a franchisor and you have a non-compete agreement with the franchisees, this does not apply. Does not apply to franchisor-franchisee relationships. They also does not apply to a specific classification of employees, which they call senior executives, and that there's a salary threshold to that their specific salary, and it's about $151,000 in that range, and there might be duties that involved. But if you have a senior executive, or if you're a senior executive and you have a question whether your non-compete applies to you, just contact an attorney, and then that attorney can give you the interpretation whether or not it does apply. The other exceptions, it does not apply from, say you buy a business or sell a business. And let's go, for example, you're selling your business, and then customarily when you sell your business, you have a non-compete agreement which prevents the seller of the business from competing against you. Okay, so you're buying the business, so you want to make sure that the seller who's selling you the business does not compete against you, and that those agreements will be binding. It does not include the bona fide sale or purchase of a business. Does not include it. Another area as well, in terms of, and I was looking up through the document, licensing agreements, and usually you have business-to-business type agreements that are made. And from my understanding in this law is that it does not include when a business makes an agreement with another business not to compete. Usually have licensing agreements that are made, sometimes in software. So that does not apply to this particular law. the focus of the law was basically focusing on employees and having an agreement that really prevents them from working for a competitor. And what happens sometimes is that the agreements that I've seen that, you see them a lot in sales, computer sales, any type of sales for the most part, that you have non-compete agreements, but they prevent that particular employee from taking a job anywhere in the United States in the same industry. That would have not been enforceable even before this law becomes in effect. But the cost of trying to find that out, it became a deterrent for this particular client who had me review that agreement from going forward with that decision, going forward with trying to find that new position, even though it really would have not affected the prior employer from in any way. If the job is the employee is in California and then the job is in Florida, for example, same industry but different company, it would not affect that particular company that much. But the idea of the potential litigation became a deterrent that particular client decided they go in a different direction. And that's the reason why this particular law became in effect. Now, I get, calls from also employees, as you can see, or independent contractors. And independent contractors do sometimes assignments. They do assignments by the month. They do it's a very short-term assignments. And for whatever reason, the business owner makes them sign a non-compete agreement for 2 years. That you cannot compete even though you have your own business. You cannot compete against them, work for any other competitor for 2 years, even though you did a 1 month assignment. And so you got to be practical about this. So those particular agreements will no longer be valid once this law becomes in effect, and it's about maybe 4 months from now. So my recommendation, if you're an employee or an independent contractor that you currently have a non-compete agreement, then contact an attorney, have that attorney review that for you, and interpret the contract based on the current law, based on what is going to happen now, and how does that affect you. And that's really what my advice is today. Obviously, read up on it. When my show notes, I'm going to have a link to the FTC website that gives some clarification, and they have kind of a chart and a summary: who does that apply, who does not apply, doesn't apply there, the law. But it's important to understand how will that affect you if you are currently issuing non-compete agreements to your employees, or you currently have signed one. Another exception that is part of it is if there's a current cause of action, is a current litigation that involves non-compete agreements, that is still current. This particular law does not affect any type of enforcement of any current litigation that is going at the present time. So it does not affect any current cause of action. Another question that I received is, okay, Rich, what about non-solicitation agreements and NDAs? Can I do that? Let's talk about non-solicitation agreements first. Okay, there are two types that I discussed, and I discussed those in the past in prior episodes. And now, obviously, I will have to make changes in some of the things that I draft for my clients based on this new rule. So you have the non-solicitation of customers that your current customers. I've seen non-solicitation agreements talk about current customers and prospective customers. What the FTC is saying is that, yes, they kind of work as a de facto non-compete. A functional non-compete is the actual term that they utilize. So if you have a situation that the non-solicitation agreement is narrow enough to protect your customer base, but it does not prevent the employee from going to a competitor, it is possible that it may pass. And I say it is possible because it has not been tested. But they didn't give you specific guidance. What is the threshold? The situation from a practical matter here is this. Now, that if you are going to enforce, say you go ahead and have an employee, you have a non-solicitation clause that we had in the past, included in my agreements, up to today, obviously, that they contacted your customers. In order for you to prove that, to be able to prevail or prove that, yes, they violated that portion of the non-solicitation clause agreement, is that you have to not only sue the employee, but you have to bring your current client into the litigation as a witness. And that's not something that anybody wants to do. You also are dealing with a situation that, what if it was the client who chose, this happens a lot in the service business, who made that contact to that former employee and said, I want to do business with that employee. I don't want to, the person left, say it's an accountant, staff accountant. I like the way he was working for me. He knows my book, knows my history. I want to go with him now. So how are you going to handle that? So there's a lot of, dynamics here in play. So one thing is to have it in writing, but how will the document be enforced from a practical matter? How are you going to prevail? And what is going to happen? What is affecting your business if you start bringing your customers in as potential witnesses to litigation against a former employee? So you got to think about that and discuss that with your attorney about, is it worth it? That's the situation. That's what I'm getting at. Now, with respect to having a non-solicitation agreement for prospective customers, even before this law, with all due respect to my colleagues, that does not make any sense, because there's no possible way that anyone can guess who are your prospective customers. So you have to kind of as long as it's narrowly tailored, the way I interpret this is that it's possible, but they don't give you specific guidance. They're also looking at the non-disclosure agreements. Yes, you can have NDAs, provided they're not overbroad and that they don't become a functional non-compete agreement. So there has to be, the information that you're talking about in the NDA has to be something that is specific to you. That's something that you basically make it very broad to the extent that, okay, I cannot do any work. I cannot work in a computer because I work in a computer in your office. So it has to be very specific to the intellectual property that you're currently utilizing in your business in order for your business to function. And that's really more on a case-by-case basis. And that's something that I recommend you talk to an attorney about. How can you draft an NDA that will not be construed or interpreted as a functional non-compete? That's something that an attorney should help you with, that understands both documents, to be able to create a document that will work well for your business. Another thing that the FTC is looking at is what is called TRAPS, and it's the acronym. It's theirs, not mine. It's a training repayment agreements. It's when you send an employee to a seminar, certifications agreement, certification program for whatever reason, whatever topic or topic or any specialization course, and then you say, okay, in order for you to, we're going to pay this, but then you have to pay us back this money, or you have to work for a specific period of time. So looking at that, they're looking at validating those two. So if you have any type of training and repayment agreement, have an attorney look at it for you and basically look at it and compare it with the law to see if that also would work. Because they're looking at specifically mentioning these agreements. And the way that, and I'm just going to read this from more of a summary, It's basically FTC finds non-compete agreements to be exploitative and coercive, and they tend to negatively affect competitive conditions in labor markets. Again, that's their interpretation. I think that there's a need for non-compete agreements. That's my opinion, provided they're narrowly tailored to protect the business interest. I don't like non-compete agreements that are overly broad, that to the extent that when you look at them, you say, you know what, this is not going to be enforced anywhere. I like agreements that are enforceable, they're realistic, and they're practical. So that's basically my opinion with non-compete, but they have to be narrowly tailored to your business interest. It cannot be for everything that you believe any competitor or any potential competitor or any prospective customer that you may think you might have in the future, because that's just not going to work. You have to be somewhat realistic and some understanding that some people are going to leave. And also at the same time, some of your competitor employees may end up working for you as well. So you got to there's going to be some competition here. What is going to be the effect of this? I do not know. So we'll find out on that. As I mentioned before, thank you for indulging me today. I'm actually going through my notes because the ink is still wet, as we say, because basically this became effective yesterday. I know you're listening a week later, but I wanted to give you this information as soon as I have it. And then what I'll do is I might do another follow-up as I get more guidance and more information from the FTC, and then give you that information as well. But for today, the key points you have to remember is that most non-compete agreements will be invalid. If you have one for your employees, have somebody take a look at those, so that way they can comply with the new guidance. If you're a senior executive and you have a senior executive in your company, have that reviewed by an attorney as well to make sure that it complies. It's an exception to the current law. If you're a franchisee, it does not apply to you. If you sold your business or you bought a business, don't worry. The seller of that business is bound by the non-compete that they signed. So those are kind of the key points I wanted to leave you with. And if you have any questions, and I'll have two more points. One more point that does apply to independent contractors. So that is important as well. So if you have an independent contractor that you gave a non-compete agreement, you might want to take a look at that non-compete as well. And if you're an independent contractor who has one, that should be reviewed as well. And that's my recommendation. But I wanted to at least give you that guidance as it came in. This brand new law that came in was announced yesterday by the Federal Trade Commission. If you have any questions about this topic or you'd like to reach out to us, my phone number is 866-842-5202. My website is floridasmallbusinesslegalcenter.com. We're at Facebook at FSB Legal. This podcast also is in video or YouTube. And our YouTube channel is youtube.com/@RichardSierra. Remember that Business SOS, 8 Common Legal Mistakes business owners make and how to avoid them. It's available on Amazon, Barnes & Noble. You can ask for your local bookstores. You want to send me an email about this topic, or any other topic you'd like me to cover. My email is rich, R-I-C-H, @richsierra.com. Until next week, this is Rich Sierra. Remember that my goal is to help you succeed.